So, what does the new Chips Ahoy marketing director do on the first day of her job? She enables cookies. Okay, continuing on with Chapter 8. Another important domain for technology product managers to consider is the intersection of product sales and revenue with service sales and revenue. And what you see in Chapter 8, figure 8.5, is the 2x2 matrix crossing products with services. And in this podcast, I'm only going to consider two of these cells, essentially the cells that focus more on the high-tech area, which is cells 1 and 2. When a company sells a high-tech product, for example, servers, companies can usefully augment their product sales with a service revenue stream. For example, this might be a repair and maintenance contract. It could be for ongoing training for company personnel. And the issues if a company decides to add a service revenue stream is, do they have sufficiently trained service personnel to actually be successful in doing this? It's an easy thing to say, we're going to add a new revenue stream with services. The reality of training service personnel who can interact well and professionally with customers and to have the sufficient number of personnel to manage the number of customers that a company has in its portfolio is critical. The fact is, service capabilities are very different than capabilities in product development and manufacturing. And a company needs to think those things through quite carefully before adding a service revenue stream. There is a cell that essentially is pure high-tech services. And what we see here, this includes contract research firms, IT consulting, and other types of high-tech service providers. And in this particular cell, the questions that a company needs to ask is, if they're going to provide high-tech services, oftentimes each customer requires a high degree of customization. And what companies try to do is actually create some sort of a platform for standardization, because otherwise they never generate any economies of scale. And the only way for them to scale up is to add more employees. And so it becomes very difficult for a pure high-tech service company to grow and remain profitable. Another strategic consideration is how technical service personnel communicate. And when you're engaged in a high-tech industry, the disparity between engineering lexicon and customers' language are very different, and there's nothing more frustrating from a customer perspective than talking to a consultant who you don't understand what they're saying. In addition, service reliability is critically important, and if a company does not consider this carefully, its reputation will be damaged in the market. And any company who's engaged in providing consulting services in the technology arena better stay abreast of new technology trends, or they're going to be dated very quickly. The final section of this chapter that I'd like to talk briefly about is the section on intellectual property. This is critically important for high-tech companies because the fact is most of their sources of competitive advantage in the market are related to know-how. And a company needs to have a strategy to protect its intellectual assets in order to be successful. There are 4 main types of intellectual property protection in the United States. First of all, a patent gives the owner of the invention the right to exclude others from making, using, or selling the invention. And this is a really important point of distinction, this right to exclude. It doesn't give the owner exclusive rights to the innovation, it gives the owner rights to exclude others, which means that the burden of patent protection is on the owner to sue other people who infringe on their patent. So that's a very important strategic decision. And then if a company doesn't have the resources to protect its patents, then the expense and time in securing a patent may be a questionable investment. The requirements for patent protection essentially are that it has to be useful, it has to be novel, which means that the invention must be a new idea, and the invention must be non-obvious, meaning that other people wouldn't have thought of it very easily. Patent protection in the United States does last 20 years. There are essentially two types of patent applications in the United States. A provisional patent application essentially is a placeholder that allows a company 1 year to do further research on their technology before they decide to file what's called a utility patent or a full patent. And because in the United States the date of invention is critically important in determining patent ownership, this provisional patent essentially establishes a priority date of the invention. After this 1 year time frame is up, then the company has to either convert their provisional patent to a utility patent, or they essentially let their provisional patent die and any other company is eligible then to go ahead and pursue a patent on a similar innovation. This utility patent application process can be quite lengthy in time, and the appendix to Chapter 8 is written by a patent attorney in Silicon Valley who essentially goes through some of the life of a patent, page 308. Another form of intellectual property protection is a copyright. So I'm going to go ahead and go back to the copyright slide. Copyrights protect the form or manner in which an idea is expressed, and this is typically used for artwork, software, books, things that essentially are expressed in an artistic form. Copyrights don't require any formal filing, and people who essentially develop works of art are granted exclusive rights to do that. But if there is a question of ownership, having filed for a copyright mark can help a company in protecting any violations. Trademark law essentially protects the symbols that a company uses to identify its brand. Trademark law is different than patent law, and companies do need to think about securing, oftentimes with a Circle R, a registered trademark, how to make sure that counterfeiters can't unfairly free ride on similar logos or icons. Now, some companies prefer trade secret protection, which essentially a trade secret would be any useful information that helps a company with its source of competitive advantage. And the big benefit of trade secrets is that as long as a company has taken steps to maintain its proprietary nature of this confidential business information, it is never made public. And this is very different than a patent, because patent databases are public information, and many companies choose not to pursue patents simply because they don't want other companies to be able to see how they made their invention. If a company is going to offer or to go after trade secret protection, it has to take great care to show that it has attempted to maintain the confidentiality of its business information. So these companies will have employees sign non-compete agreements that they won't go to a competitor's firm within a particular time frame. They'll have outside suppliers and consultants sign non-disclosure agreements that the partners won't disclose this very confidential information. And they'll also have employees sign invention assignment clauses that essentially say anything that an employee invents during his or her employment with the company does belong to the company. Given that there are pros and cons to both patents and trade secrets, it's useful to consider when one type of protection might be more useful than another. When products are going to have a long market life, for example in the case of pharmaceuticals, when products can be reverse engineered, which means a competitor can take them into their lab and essentially take them apart to see how they work, such as in hardware, then patents can be important. As I mentioned previously, when the company does have sufficient money and time to actually protect its patent, and when it's just a matter of corporate policy that the company patents its inventions. IBM and P&G both have this as a corporate policy. On the other hand, trade secrets are generally more useful if, in fact, the confidential information doesn't meet the criteria for a patent. It's either somewhat obvious or it is not novel. If the product life cycle is very short, oftentimes the product is already obsolete before the patent process has even been completed. If the patent is hard to enforce, or if the secret is not detectable in the product. For example, it's very famous that Coca-Cola has always relied on trade secret protection for its product. I would also like to add that patents can be quite expensive in terms of the amount of money it takes to secure them. I would also like to note that patents can be quite controversial. The basic philosophy in intellectual property rights is that society has to balance giving the inventor an incentive to innovate because they can secure some proprietary period of ownership of the invention against societal needs to have non-monopolistic business practices and to have other companies who can capitalize on earlier innovations. Securing good help with a patent attorney is critical, and some of the most problematic areas in patent protection can be when company engineers present their work at conferences. It can be an absolute bar then for that company to secure a patent at a later date because it's no longer considered non-obvious. Another issue oftentimes in securing patents is not having good lab notebooks that actually identify what the date of invention is. There's a difference in the global patent community about what is called first to file versus first to invent. And that discrepancy across the world sometimes means that having a lab notebook that actually verifies when the invention occurred can be critical. I think that gives you a sense of some of the issues in patent protection. I think that the intersection of technology and law is just quite interesting, and I encourage students who are interested in the patenting issues to look quite carefully at the appendix to Chapter 8 that provides useful information about this life cycle of the patent and some of the costs that are involved in securing a patent.